Well, hello and welcome everyone to another session in the Solid Finances series. A couple of reminders here. First of all, our sponsors for this series, Montana State University Extension and North Dakota State University Extension, have partnered to bring this series to you all year long. Just a reminder, kind of the goal here is just to provide you with some unbiased resources and help you build skills and confidence so that you can make better choices for yourself as you face different financial decisions in your own life. We do want this to be as interactive as possible, even if we are in the sort of webinar world where we can't necessarily see you, but we do want to interact with you. So one, we have a question and answer pod at the bottom. Please feel free to send in questions. It is anonymous when you send them in. And we'll just say we've had a question come in, and then we'll try to answer those when we get to a pause in the presentation, or we'll catch up at the end with any questions we haven't yet picked up along the way. We'll also have some poll questions to find out a little bit about you and to ask a little bit about maybe your situation and your knowledge level of some things. It's going to be just a group result, so feel free to be as open and honest as you can with those participation in the polls as well. Now, today was scheduled to be our final session in this Solid Finances series, taking a break until fall. However, in light of sort of the events of the last 2 weeks, we're going to do a special session next week. And we'll send out a reminder email, and we'll talk about financial issues for consumers that are relevant sort of currently. So we'll talk a little bit about probably the stimulus, some investment scams or frauds that we've been hearing about, and some tips from the Consumer Financial Protection Bureau as well. So myself and Carrie Johnson will jointly teach that. So 1 week from today, and we will send out a email reminder, probably 2 actually, because it's a specially scheduled session. So 1 week from today, mark your calendars, same time, and we'll cover some kind of topical issues at that time. Also a reminder, our website, we do have recordings of all of our past sessions. I left upcoming schedule on there because we do have one more scheduled for this spring here on April 1st. So if you haven't bookmarked that, it's a great resource, especially as we kind of go on summer break from the series. If you want to refer back to anything, that is where we keep all of those resources. So that brings us to today. I'm going to introduce a colleague of mine, Marcia Getting. She's been presenting this is the third of 3 weeks dealing with sort of a variety of estate planning topics. So familiar face to that. So with that, I'm going to turn it over to Marcia. And if you have any questions, please ask them, and we'll try to get those answered along the way.
Okay, thank you very much, Joel. And my goodness, hasn't the world changed for all of us? And as we look at families and legacies and these challenging decisions that go on, many of us think about having a car accident or maybe being in a plane crash, and that's what would happen. Except I don't know that I really thought about perhaps dying from the result of a virus. So I'm finding that people are very interested in this topic at this point in time. And one thing that I try to do to lighten the load a little bit as far as the seriousness of the topic, yes, it's very serious, but I like to use wildflowers because, you know, it gives us faith that this snow is going to melt in Montana and we are going to get out there and do some fun things. But I want you to remember strategies, and these strategies will help you make estate planning easier. And of course, if we can save some money at the same time, I always like that too. Now, I thought I'd be curious to find out what state that you happen to reside in. And my reason for wanting to know that is after our session last time, I found that we had quite a few folks from out of state, and that means that I should make some reference to that situation. So looks like we've got Montana represented. We've also got Idaho, lots of participants. And then we even have a guest from out of the categories that I had there. So that's super. And the reason, again, that I wanted to ask that is that we have 18 states that have adopted the Uniform Probate Code. And those 2 stars that are out there on the edge there, one is Alaska and one is looking at, oh my goodness, another state now that I've forgotten. Well, anyway, Uniform Probate Code is the term that I'll be using a lot. And this is the law that many states, 18, have passed to take in consideration that if we have 7 out of 10 without writing a will, then where is that property going to be distributed? So we'll start out with another poll. When did you last review your estate plan? So you have the opportunity to vote on you don't have one, the past year, 2 to 5 years ago, or 6 to 10. And as usual, don't have one. 33% of you are saying that you don't have an estate plan. And that's where, when I'm in one of my live presentations, I yell and scream and holler and say, hey, you just don't realize you do have one, because this is the state law that will determine where your property is going. You don't decide, then the state's going to take over for you. Now, it can also include a trust, because I'm realizing there are more people out there. So I look at a will and a trust as being very similar from the perspective that both of them talk about how they're going to distribute their property. When do they want their heirs to receive it, and under what conditions? Now, this is one of my first flowers, and I think if you took a look at that and see the name there, you can immediately tell, yeah, that's a steer's head. Look at those eyes. Look at those ears. Well, that tells me I want to steer you towards an awareness of the Uniform Probate Code for the transfer of your property. And I want to include some examples of ownership issues in there as well. I also want to steer you to a variety of estate planning tools that can show you how to avoid probate, and what that's going to do is save your estate money if you're not having to pay an attorney for the costs of probate. So this is the bitterroot. The bitterroot flower is one that is our Montana state flower, and it's a beautiful, beautiful flower, but the name makes me think about bitterness, and that bitterness that can result from lack of planning. In Montana, we have Montana law. Idaho, you have Idaho law that determines what's going to happen to your property. And when you see a black box, what that's telling you is that person is deceased. So I'm looking at the bitterroot families in the early 90s. And they started off with a husband and wife. Then they had children who got married, of course, and then they were blessed with grandchildren. So this could look like our family, your family, at any point in time. And then sad things start happening to the family. You look over there, and there was a son that was killed in a car. No, this was an airplane accident in western Montana. Then we had the daughter on the right-hand side there, passed away in 2005 because of a car accident in eastern Montana. Now, the next person to pass away was dad. So dad died, which means mom had all the property, but mom did not write a will. So because she didn't write a will, state law steps in, the Uniform Probate Code, and says this is how the property is going to be distributed. So that the way that I'm going to ask you about that is, we're just quickly looking at those times again. We know that mom was the last to die. So I'm taking a look at grandchild D, where we have the red lightning bolt. And with a poll, I'm going to give you the opportunity to decide what fraction does this grandchild receive. Will the grandchild receive nothing under state law or the Uniform Probate Code, 1/6, 1/8, or 1/9?
And Marcia, while people are addressing that, a question has come in. If someone has developed a trust with an attorney in one state and they have permanently moved to another state, how do you go about updating that trust so it reflects the proper laws? Do you need an attorney or just a notary?
Okay, that happens a lot when we move. And if you have a will, Montana has reciprocal agreements with other states about a will. So if it was legal in a state that you had it written, it's legal here. Trusts are a different matter. And what I would suggest as an idea is that individuals, it's probably okay, but on the other hand, wouldn't you feel more comfortable if you just had an attorney look it over? Simply having it notarized here does not mean that it's, quotes, legal. And Montana has passed several trust statutes making some changes, but those may influence what you've got. So that would be my recommendation. Now, I've got 50% of you that are saying grandchild D is not going to receive anything, and I've got another half of you saying, well, they're going to receive, let's see, 1/9. Well, in this case, it is indeed the 1/9 folks that got it right. And I could say those of you that weren't going to give the child anything are just basically mean. Ha ha. Okay, let's take a look at that. I could see you out there maybe as one of my audiences, and they kind of pucker up their forehead and say, well, why? Why would we have a case where mom died without a will, and we've got one grandchild that receives 1/3, we've got another grandchild, or 3 of them, that receive 1/9, and then we've got these 2 that receive 0. And most states use this concept that's called right of representation. And the way that you can judge right of representation is to look at the situation of how many kids did mom and dad have? Well, they had 3. So we know right away that the estate is going to be divided 1/3, 1/3, and 1/3, because that's the number of children they have. Well, think of the turquoise child that receives 1/3. That kid kind of represents his dad, which is the son of mom and dad up there. So since the son was deceased, his 1 share passes to his child, and that child receives 1/3. Notice it did not go to his wife, because Montana recognizes bloodlines. Now, if a child is adopted, they're treated the same as a biological child. So this right of representation is a very, very important concept to know, because we had 50% of you that don't have an estate plan. So some of you have a will, and you're thinking, well, I don't even need to pay attention to this part. Hey, take a look at your will. Does it say that your property is going to be distributed by right of representation? And did you understand that? I know I didn't when the attorney tried to tell me about it. And finally, I got so frustrated, I just said, would you please draw me what you're talking about in my family situation, so you could do the same thing for yours. So parents and grandparents really do need to decide if they want right of representation to apply in their individual family situation. Now here we have the Larkspur family. And I was kind of tickled when I was giving a meeting. I had one lady there said, you know, this is really a bad flower to include in a presentation such as this because they are toxic. And I thought, I love it, because then I can talk about toxic family relationships. So here's the Larkspur family. We've got mom and dad up there. And the situation here is that we've got a brother who is got a black in there. So that means he is deceased. So let's say that he died without writing a will. And he is survived by mom and dad. And he is survived by 4 siblings. And we've got 6 nieces and nephews. So what we want to look at there is what relatives have priority in this particular case. The son dies, which is also the brother. What relatives have priority? Well, my goodness, I see I didn't fool you on this one. You are exactly right. It's mom and dad that have priority to inherit his property. So that means they would receive half and half. And then if we only had one surviving parent, then dad, in this instance, would receive it all. But now let's take a look and say, if the parents are deceased, who comes in next? Is it going to be nieces and nephews? No, it's going to be the siblings. So in this case, each of those siblings is going to inherit the property. And I see all kinds of challenges with something like this. Whether you've got a home located in your community, you've got a nice little cabin at the lake, or even a farm ranch, getting those four siblings together to agree on a decision becomes kind of a challenge at times. And this is what the Uniform Probate Code refers to as equal or per capita. Now I'm going to use a different situation. You can see from this that we had one sister that died in 2001, another sister that died in 2005, and then the brother passed away in 2011. So mom and dad are gone, and what I want to know then is what fraction, if any, are you going to leave to the brother with the red lightning bolt? So what fraction, if any, will that larkspur brother receive? All right, it looks like we have some interest there. We've got 50% that said a fourth. We had 33 that said a half, and then we had 16 that said all. So let's take a look at that, because in this case, half of you got it right, but the other half missed. So let's look at that. What is going on there? You see, we have another case of right of representation. And the person that we're looking at this time is the brother. So now we ask, how many brothers and sisters did this individual have? And he had 4. So that right away tells us 1/4, 1/4, 1/4, and another fourth. So you see, in this case with the sister that had deceased, this was the niece here, and her mom is deceased. So she receives the share her mom would have received had the mom lived. Now, the sad thing about this situation is this particular niece moved to New York City 20 years ago, and she really hasn't had time for her Montana relatives since then. You know, she thinks we're all a bunch of hicks. Well, gee, she gets 1/4 of the estate. And then we have the sister that had also died, but she had 2 kids. Well, unfortunately, one of the nephews there was arrested for drug dealing, and he's in prison. So I wish I could have sat down with the gentleman and said, you know, if you don't write a will, I want to show you how your property is going to be divided. And if this is not what you want, you really do need to write a will. Now, it could have been a situation where the sister had lived, and if she had of, then under right of representation, we still have that honorary niece receiving a fourth, but the sister received a fourth, and then the 2 brothers 1/4 each. And what do you think the niece wants in a situation like this? Yeah, what she wanted was money. She's saying, buy me out. You know, you guys get to go to the cabin. I'm not. I'm in New York City. Just buy me out. And if you've got a place on Flathead Lake, you know, it's going to be a couple of bucks to have to buy her out. Now, it could have been our bachelor brother could have written a will, and he could have decided that what he wanted to do was leave the property to his favorite nonprofit organization. And that could have been the Montana 4-H Foundation, Idaho 4-H Foundation, or even the North Dakota 4-H Foundation. That would be nice for those organizations. So I advise single folks to take action, and if they've already got a will, take a look in that will, and if right of representation was included, do you understand what that means? And then you can avoid some toxic family relationships. Now, I've got these pink monkey flowers, and because there's 2 of them, that makes me think of joint tenancy property. And what we've got here is joint tenancy between parents and children. And that's what Sarah's done. You know, she's getting up in years and she's decided she wants Susan to help her with paying the medical bills for the newspaper and buying groceries, etc. So as the ladies were sitting around the coffee table, they advised Sarah to put the checking account in joint tenancy with Susan. So Sarah did that, and then she said, well, I want to make sure that my three children equally inherit that money. So she wrote a will, and she divided that equally between her, or among her three daughters. So what I want to know is, how is the $80,000 divided? Is it equally among Sarah's three daughters, all to Susan, all to Carrie, all to Jane, or all to Montana, because we have a conflict between a will and joint tenancy contract?
And Marcia, this might be a little bit of a related question, but we had a question come in about, and a participant here has property that has a beneficiary deed, but it also has a will, and the beneficiaries do not match, and the beneficiary deed is more recent than the will. Which of those documents will be valid?
Okay, what counts is the beneficiary deed because it's a contract. And it doesn't matter if you wrote a will before or you wrote a will after you filed the beneficiary deed. The section that says, in the will, I leave this property to Jane, and you've got a beneficiary deed with it going to John, John is the one that's going to get it. And that's the same thing here about how the 80,000 is divided. Joel, I guess I didn't see that result. Sorry, I was concentrating. But I'll just give the answer there. And indeed, it's very similar to the beneficiary deed, because what we've got here is daughter Susan is going to receive it all, even though mom had written a will saying, I want it to go equally to my three daughters. And that's something that we've got to realize, that anytime we have property in joint tenancy, where whoever we have it with, that is who is going to receive that property. A will is not going to control. So joint tenancy, this is true in Idaho, North Dakota, and other states. The joint tenancy takes priority over a will, and it doesn't matter when that will was written. But we do have some states that have done something about that, and they say, you know, we realize that as we age, people may want to have somebody that signs the checks. But then that person doesn't have what we call beneficial ownership in that checking account. So the Montana Multiple Party Account form allows for what we call an agency designation or multiple party designation, but this person has no ownership rights in that $80,000, for example. So you put a X on multiple party account without right of survivorship, or on the agency designation, either one, and then mom's will comes into play. What we've got is then daughter Susan, daughter Carrie, and Jane all share equally in that $80,000. And we understand that that's what mom wanted. So if she had an opportunity to do that, she should. And that's something a lot of us don't know. Your state may have passed something like that, and unless you've opened up an account lately, you don't even know about it because you haven't had that opportunity. So we have an extension Mont guide. That's what we call fact sheets in Montana, and it's on non-probate transfers, and it provides a sample of that form. So that way you have a chance to look at it before you go to the bank or credit union to have one of those accounts. Now, my reflection for the pink monkey flowers then is, use that account act when it's appropriate. Now these happen to be white mule's ears, and that makes me think about a phrase. Have you heard mom or dad and you say, Mom is just stubborn as a mule? Well, I think I said that more than once about my dad. So what I want to do here is examine the consequences of Dad being stubborn as a mule. Okay, so here's Dad. Dad has some property, And he has it in his name only because his wife died several years ago. And he has two children. And Dad's practical. Why should I pay to write a will when I know my two children are going to inherit it equally, and that's what I want anyway? I'm not going to spend the money. Well, things change, and he is right. Montana law, anybody that's got the uniform probate code will say, yeah, the kids receive one half each. But look what happened in the year 2010. Dad got married. And to show his love for his new wife and her love for him, they put all their property in joint tenancy with right of survivorship. And Dad tells his kids, don't worry, I've written a will and you're going to get the ranch. Okay, Dad the mule dies. And the question becomes then, will Dad's kids get the ranch because his will was written after the joint tenancy was formed? Do Dad's kids get the ranch? Yes or no? Hooray, hooray! That 50% of you that missed the last one got it right. We had 100% that got that one right because you said, no, everything is going to go to the wife because of that joint tenancy. So you see what has happened here is Dad has disinherited his two children. And I actually had a gentleman like this at one of my meetings, and he was just furious. He didn't think I knew what I was talking about. And, you know, we talked over coffee and we all got it worked out. But he was just amazed because he thought by writing a will, his new wife would get like part of this and not all of it. Anyway, very, very interesting. So we could take a look at that and we could say a few years pass and now the new wife dies with all the property. Now who inherits? Her kids. She dies, her kids are the ones that inherit the property. So then let's just take a different example, saying the new wife remarried. And what she did was place the property in joint tenancy with her new husband. Then she died. And, you know, what she did was marry the good-looking hunk in Missoula, here in Montana. So that is a concern about remarriages and why the kids get concerned, because this case, the new husband got it all. Stubborn mule dad's kids, nothing. And I think I would almost call the wife stubborn too, because she disinherited her two kids as well. So we really need to be clear. And yeah, maybe I like to keep it even. Maybe Dad married the wow wow floozy, but what is it that we can do? So the lesson learned is that joint tenancy with right of survivorship may not be the best choice if we want to provide for children from a prior marriage. So I think our estate planning goal would be to provide financial protection for both the spouse and the children. And we can do that. Here's one way, only one way, there's others. But this is a life estate, and when you have a life estate, you have a life tenant and the remainderment. So what this guy wanted to do is make sure that his wife could live in the home for as long as she was alive. He did not want his kids trying to kick her out of there. And then he wanted his farmland, however, to go directly to his children. So what the husband and wife did was sever their joint tenancies and put the property in his name, and then she also put her property in her name. You see, she also had property that she wanted to go to her kids, but she put it in joint tenancy with this hunk. So we then say she stays in the home, and then the property goes to the remaindermen, which are his kids, after she passes away. So that's a tool that can be used. So seek legal advice before you do title property, particularly if you're getting married. And take a look at a premarital agreement. Hey, that's a good way to let your kids know that you've thought about these things and that they're protected. And if we already have a remarriage, I found out that you can write a post-marital agreement. And I had a call from a gentleman just the other day that really needed to do that because he says, well, we verbally agreed to this, but, what if my wife gets Alzheimer's and in the early stages transfers property to her kids and not my kids? And so a post-marital agreement with each party having an attorney would take care of that challenge. Now here we have one of my favorite flowers, and on the left is an albino, and that's why I call it albino, because it's white. And we have the fairy slipper, and that's what it looks like normally. Well, of course, when I found this, I figured I have to include it in my presentation because it's so neat. So, of course, we have John and Mary Albino. And what they did was tell friends and relatives, and you've heard it from here, that they want to leave their property to the MSU Alumni Foundation. Okay, and what we've got though is the property is titled in John Albino's name only. Now let's say they have an accident. John dies immediately, Mary dies 3 days later, and we hope it's not the coronavirus. I keep messing that word up. Anyway, there's no will, there's no kids. So the question for poll age is, who is going to receive that property that's in John's name? Is it going to be John's relatives, Mary's relatives? Will it go half and half, or will the MSU Alumni Foundation receive it because verbally you all heard them say that? Okay, it looks like we got half and half again. So let's take a look at really what happens with this. Now, I bet some of you that said Mary's relatives are thinking very realistically. You said if John dies, Mary receives it all. She dies, then it goes to her family. And that would be true if you were in Kansas, but you're not. You're in Montana. And Montana is going to give it to John's relatives. But the real reason of why that's happening is there is a survival requirement in the Uniform Probate Code. And it says an heir must survive 120 hours. Otherwise, the heir is treated as predeceasing the decedent. Okay, that's legal speak. Let's just do it in our language. In this case, Mary is treated as predeceasing John because she died on the third day. So that's within that 120 hours, and that means then John's relatives receive it all. Now, I'm trying to get John and Mary to write a will, and they've told me they don't need one, and John even said that after I showed this illustration. So I said, okay, John, here's the situation. What if you die immediately from a virus, and Mary hangs on for 6 days, and then she dies? Now who is going to receive the property? Aha, Mary's relatives. Yes. So, man, it was really fun. To use those two examples, I got John and Mary to write a will. And then they made an appointment with their attorney so that they could leave a bequest to Montana State University Alumni Association, or in this case, Foundation. So the reflection from the albino fairy slipper is that married couples who are traditionalists, maybe they have solely owned property, each one needs to write a will that controls what nonprofit they want to receive their property when they both pass away. And maybe they don't have a nonprofit. Maybe they have nieces and nephews. It's whatever they want. It's their property. They need to decide. Now here I have a heart-leafed arnica. And what that makes me think about is some heart-to-heart estate planning that Joe Hart and Brooke Hart are doing. And all that Joe, he has heartfelt intentions. He's leaving a $100,000 life insurance policy to his sweetheart, Brooke. You know what? Later he changes his heartfelt intention and he writes a will. And he's saying, now I bequest all life insurance proceeds to my son, Eric Hart. Well, you know what I'm going to ask you, don't you? Okay, we've got that change. Who gets the $100,000? Is it Brooke, the designated beneficiary, or is it Eric because he's called the devotee? That's a word you should know because you write a will, you are the devotee. Okay, so Brooke or Eric? Oh, you already got that one figured out. Good for you guys. Because what that means then is, yep, Brooke is the designated beneficiary. That form is serving as a contract. And of course, that contract can be changed. If Joe wants to change beneficiaries, it's very simple. He just needs to get a new beneficiary designation form from the company, and some of them even have it online now. Send that to his life insurance company, and he has a new beneficiary designation. So the Montana Uniform Probate Code says you can't undo a contract with a will. And you guys are so good that you don't even have to say this out loud in front of your computer. But in my live audiences, I make them shout out this with gusto because it's important to remember it. And you can share that information with somebody that you're having lunch or coffee with another time. So my reflection from the Heartleaf Arnica is have a heart, review your beneficiary designations on your life insurance policies and IRAs. Now this is a mountain death canvas, and I'm sad to say that was a card that I made in my early days of wildflower hunting, and I unfortunately sent it to a friend's mom who had cancer, and I felt awful that I did that. But she was so nice. She wrote a really nice letter saying, yep, they lost 7 sheep to death camas when they were grazing in the Lima Mountains. But what the death camas makes me think about are pods and tods. And if you've got a payable on death designation on your checking account, savings accounts, and certificates of deposit, you avoid probate. Okay? At death, the ownership of that account falls to the person that you put, POD for. There's no probate at all. All that person will need is an affidavit of death and a government-issued photo ID. So this is something all of us can think about doing on our financial accounts there. And even if we've already got a joint tenancy with a spouse, why not go ahead and put a POD to your 2 children? Or you could do a POD to a nonprofit if you wanted to. PODs will save you money. Now, those of you that still have stocks, bonds, and mutual funds, what you can do on those is put a transfer on death registration. Now, many of you already had a beneficiary designation when you opened the account. But we had some companies that were not allowing beneficiary designations, and Montana passed a law saying if you're going to do business in this state, you have to have one. So you do that TOD, and then the TOD beneficiary makes the decisions about the mutual funds, stocks, bonds. Are they going to keep them, or are they going to sell them? And I usually like to ask my audiences, is this a wise idea to sell those? And people often say, no, don't do it because there will be a capital gain. And that's because they don't know about property at death. Now, all property, it receives what we call a step-up in basis. And that's the fair market value at the date of death. And it doesn't really matter if you used a transfer on death deed or a transfer on death registration, etc. What it means is that it's stepped up in value. So if you had a home and you were leaving it to someone in a will, it still gets a step up in basis. However, property that's gifted has what we call a carryover. So I'm thinking right now of our home that we have in Bozeman. Well, way back in '77, paid, let's see, about $45,000 for it. And then we had a house across the street sell for $450,000. Oh, we about had a heart attack. Well, I die, then if our house had a value of $450,000 and it was sold, There's no capital gain because it was sold at the rate of the fair market value at the date of death, which is kind of cool. You can also POD and TOD to your charity or nonprofits. So we have a Montana Community Foundation that's very active. We have the MSU Alumni Foundation and also Montana 4-H. So I'm curious to ask you then, look at how you can control your property distribution and avoid probate fees at death. Now that you know about them, would you place them on your financial accounts? All right, looks like we have 83% of you that would like to do this, but about a fourth of you have the accounts already. So there's some work to do when you get through out of this session. Now this happens to be an explorer's gentian. And what it makes me think of is transfer on death deeds. These are new in Montana. It was passed and effective October 1 of last year. This is one that I don't know if North Dakota, well, no, I know North Dakota has, but I'm not sure about Idaho. But if they don't have a transfer on death deed, it may be referred to as a beneficiary deed. So what it is you can decide ahead of time who you want to have the property. And that designated beneficiary has no rights whatsoever. They can't sell it out from under you. They can't use your home as collateral on a loan. The beneficiary is not the owner until the person passes away. So you record your transfer on death deed in the clerk and recorder's office in the Montana County where the property is located. Okay, where the property is located. Now, who can be your designated beneficiaries? Almost anybody, spouse, children, relatives, friends, a corporation, and nonprofits. So, for example, I was in Glendive a couple of weeks ago, and they had the Glendive Medical Center, and they have Montanans for Children and things like that. So your designated beneficiaries can be whoever you want it to be. So my reflection on Explorer's Gentian is just think about it. Would a transfer on death deed be an appropriate one for your situation? And then I'd like to share a little bit more because we have a foxglove here, and I want you to be foxy because you've got to think about what if the designated beneficiary dies before you do? Be foxy, specify a successor. In other words, it's like writing a will. The attorney will say, who do you want to receive it first? Well, if that person is killed with you or before you, who do you want next? That's what we're thinking about. So Mark has done that. Mark files and records a transfer on death deed, and he's saying Evan Fox is the designated beneficiary. But he goes further than that. He says, if Evan dies before I do, or with me, I want it to go down to my grandson, Luke. So we've got a successor in there. And unfortunately, Montana law did not put that category in there. And my co-author on the Mont Guide that we're working on really wishes they had it, but we're including it in the Mont Guide so that you can see what it would look like. Now, you don't have to have just one. You can have a couple of beneficiaries. Oh, I bet Joel put that in there, didn't you, Joel? Ha ha. Okay. Now, outfox the law and make sure that when you do a transfer on death deed that you designate a successor beneficiary. Now, this happens to be a blue flax. And that reminds me of Gary Blue and his two blue children. We got Gary Blue, Linda, and Matt Blue. And Gary files a transfer on death deed naming his daughter as his designated beneficiary. Okay, you know what I'm going to do? Yes, Gary wrote a will. And in the will, he's leaving the same property to his son. So, of course, I'm going to ask you, who is going to get the property when Gary Blue passes away? Is it Linda Blue, the beneficiary, or Matt Blue, because he was named in the will after the filing of the transfer on death deed? Alrighty, I didn't fill you with that one either. But of course, if you were listening, I kind of answered that with the beneficiary deed question there. But you're right. Linda is the one that's going to receive it. Now, can you imagine Thanksgiving or Christmas in this household? Matt is really upset because he didn't get anything. He's saying Dad wrote a will, so that's very obvious. He wanted me to receive it. And so I don't think Matt's probably going to show up for Thanksgiving. And what Matt is doing is singing the blues. On the other hand, maybe Gary wrote a will or filed a transfer on death deed and left it to the Alzheimer Association. And that specifically is the Montana chapter. So my observation from the Lady Slipper is that time has passed away, or slipped by, let's just say that, and it's about time to wrap it up. But I'd like for you to feel free to put in any questions that you'd like to have, because I hope I did steer you towards an awareness of the Uniform Probate Code for the transfer of your property. And then we looked at some ownership issues like sole ownership and joint tenancy with right of survivorship. And there's a lot more to know about those joint tenancy examples. And then I also steered you to a variety of estate planning tools that can avoid a costly probate. And what that will do is save your heirs money. That means that you can give them more things. Now, if you don't have a memory like this elephant's head, now for those of you that have not seen one of these, yes, it's an elephant. You see the trunk and the ears. You can tell on a wildflower nut. We have 43 different estate planning publications with MSU extension. Now, North Dakota also has a series on estate planning, and I'm aware that my colleagues in Idaho have also got those kinds of things. So just Google estate planning Idaho, and you'll get the Idaho extension, and same way with North Dakota. So don't forget, these Mont guides are available from our local MSU county extension agents, and they would be glad to print those out for you. So Joel, are there any questions out there that people would like to have answered?
Yeah, I'm going to ask one question here, and then we'll take a little bit of a switch over and we'll do a little bit of an evaluation, then we'll come back and do some more. So one question before we go is, do beneficiary deed changes require an attorney, or are there forms available that hold legally that are online?
Okay, this is always an interesting one because there are all kinds of forms that are out there. Now, right now in Montana, people should not be using a beneficiary deed form. As a matter of fact, the clerk and recorders have been notified because we had one county that had already approved or notarized, filed, whatever, 54 beneficiary deeds, and those are out of touch. So what we're doing extension, I mentioned we're doing a Mont guide, and we will have the form in the Mont guide. And man, I was hoping we'd have it available by this time, but circumstances with everything that's been going on, even the attorneys are not returning the reviews that they have. So if you could kind of hang tight, certainly in Montana, we will have a Mont guide, and we will have the forms with the successor beneficiary included. We found the statutory form that's in there, it was optional. So that allows us to add in that successor beneficiary category.
All right, thank you. And we'll pause here for just another maybe 5 or 10 seconds and let people enter in any final comments. And then we'll go back to the other screen and you'll have an opportunity to send us more questions as well.
Yes, it's a very good idea to review your beneficiary designations. I had a gentleman in my audience once that actually had beneficiary designations that were 30 years old, and some of those people weren't alive anymore.
All right, and we do have one more question that's come in here. Can a beneficiary be worded so it is to one person, so for the benefit of the heirs of the descendant per the will, to simplify and not have tons of people being named as beneficiary, but to make sure the person named does the right thing in sharing with other heirs per intentions?
Okay, the challenge with leaving it to one and expecting that one person to distribute everything is really not fair to that individual because no matter what he does, everybody else thinks that he skims some off the top. Now, here I'm talking about families that don't necessarily get along. But I've had that situation even with safe deposit box. You know, mom and dad put the oldest child's name on the box, and then what happens is that child goes in and does things, and invariably the two other kids are jealous, or maybe there's things that happened in the past. So if you're writing the will, you got to remember that unless you're going to form a trust and say, I'm going to leave it to John, and John is the trustee, or no, I'm going to leave it to John as the trustee of my trusts, and then the trust is going to give it out 10%, 10%, 10%. But in your will, if you just say, well, I want it to go to the lineal descendants by right of representation, then you're getting into the examples that we had earlier. So a lot of you are in states with the Uniform Probate Code. I notice we have South Carolina. You'll want to check with your extension service in the state to see what they have available.
All right, and we've had one more question come in, Marcia. If you have a trust, is it the beneficiary for all of your accounts? How do you name a successor for your trust?
Okay, when you that's one of the things that you could do. You could do PODs, TODs, transfer on death deed, and you could say everything goes into the trust. And then you've got to decide what is the purpose of this trust. Are the assets there going to be used for the health, education, maintenance, and support of your grandchildren or your children? And you can say, well, I had one lady, she receives her trust at age 65. You know, and so you can do in there whatever it is that you want to do. Or you can say all of these kids get income for 20 years, and then whatever's left goes to a nonprofit or your favorite charity. You are the one that needs to decide what you want to have happen. And then that's where I see the attorney coming in and saying, I would recommend X or X. You know, do we want a living trust? Do we want a testamentary trust? A living trust is the one that you form now, and you change everything that you want in there into the name of the trust. And then the trust document, think of it as a will type thing, the trust document determines what's going to happen. Now, if you have a testamentary trust, you have the will, and you've got your PODs, and there's a section in your will that says, if I forgot anything, it all goes into the trust. And then the trust takes over and does what you want it to do. And you just got to decide, are you going to have dead hand control? I mean, I've got one lady out there, she is wanting to control it into perpetuity. And no, Montana trust law will not allow a trust to last forever. If you're going to do that, you need to look at having a foundation. And that's a lot more complicated.
All right, well, thank you very much, and thank you for the questions, everyone. For those of you that didn't catch Marcia's previous two estate planning sessions, this was the third of three. I would encourage you to go to the website and watch the recordings of those. And today's recording will be posted in a couple days, so that'll be there as well in case you'd like to share it with someone who wasn't able to attend today. And then a special programming note, we have extended the Solid Finances series for one additional week, 1 week from today. We will talk about financial issues for consumers with respect to the COVID-19 situation. So that will be 1 week from today. We will be sending out a reminder email and a little bit of a description about specifically what we'll talk about during that session. So with that, thank you everyone for joining us. Thank you, Marcia, and I hope you all have a great day, and I hope to see you next week.
Keep healthy, everybody.